Today, in a tense courtroom in Missaukee County, Mr. Jason Elmore LaRoche faces the consequences of a series of serious crimes. Multiple cases, multiple charges, home invasion, felonious assault, and more are all hanging over him. In a pretrial agreement, some charges will be dismissed, but two key counts remain: a violent assault with an axe and a second-degree home invasion. As the court reviews the facts, witnesses, and the plea, we witness a critical moment of accountability. Mr. LaRoche knowingly waives his right to a trial, to challenge the evidence, and to remain silent. The stakes are high, the tension palpable, and every decision in this courtroom will shape the path ahead. Stay with us as we unpack the drama, the facts, and the shocking events that led to this pivotal day.
A district court case, in which case the defendant at the next hearing will plead to domestic violence in that case.
So there's the one that's being dismissed. Has that already been charged?
It has already been charged, Your Honor. It is set for a preliminary exam, I believe, this Thursday, Your Honor.
All right, and that case number is?
It's on the plea agreement. It's 25-10-48 FY, Your Honor.
Thank you. Is that a complete and accurate statement of the pretrial agreement? Plus, I see it here on the signed agreement that you've tendered to the court. Is that complete?
It is, Your Honor.
All right, thank you. For the amount of fines and costs. Is there one here? Not more than $3,000. All right, thank you. Mr. LaRoche, is that how you wish to resolve today's file, sir?
Yes, sir.
Please raise your right hand to the best you can. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
You may lower your hand. All right, Mr. LaRoche, looking back on the date of June 26th of 2025, were you on probation or parole?
No, sir.
Were you on bond pending any felony charges?
No, sir.
All right, thank you. You are currently charged on a felony information, which is simply a couple pieces of paper that serve as the charging document. And on that felony information, you are currently charged with 4 counts. Count 1 is a charge of home invasion in the first degree. That is a felony punishable by up to 20 years and or up to $5,000. Additionally, consecutive sentence may be imposed by this court for any other conviction arising out of the same transaction.
In today's court session, Mr. LaRoche faces a complex legal web, multiple cases, multiple charges, but a single pretrial agreement aims to resolve them. Felony counts of home invasion and assault hang over him, yet some charges will be dismissed. The plea ensures no trial, but the weight of consequences is real. Every right, from jury trial to remaining silent, is being formally waived. This is a high-stakes moment where choices define the path ahead.
Which I assume this did not occur within a place of confinement. Am I correct, Mr. Rupp?
You are.
Thank you. But that count will also be dismissed. Count 3 is a charge of assault with a dangerous weapon, also commonly known as felonious assault. That is a felony punishable by up to 4 years and or up to $2,000. I assume that also did not take place in a place of confinement. Is that correct? Thank you. I'm told that you will plead guilty to that count. Count 4 is another charge of assault with a dangerous weapon, again, also known as felonious assault. And again, it's a felony punishable by up to 4 years and or up to $2,000. That charge will be dismissed. So out of those first initial charges, you're only pleading guilty to count 3, and that involved a felonious assault or assault with a dangerous weapon upon a person named Jeffrey Allen Peterson. And that allegedly involved an axe and 10 to 12 pound with a 10 to 12 pound head on it and approximately 3 feet in length. I'm only highlighting that so you know which one of 3 or 4 you are pleading guilty to. Plus, you also will be pleading guilty to an added count 5. That added count 5 is a charge of home invasion in the 2nd degree. That is also a felony, but in that instance, it's a felony punishable by up to 15 years and not more than $3,000 in fines and costs, or both of those together. And the other counts will be dismissed. Now, this pretrial agreement also involves an agreement, what we could call maybe a global agreement, and it applies to 2 other cases. One of those cases is case number 25-608-SM-2, and it is currently before the district court, and apparently involves a domestic violence charge. That case, that one will be dismissed. Is that right, Mr. Downs?
No, at the next scheduled hearing, the procedural posture of the case, we've had a pretrial, it's scheduled for a final pretrial. It's my understanding that the defendant is agreeing to plead guilty to 1 count of domestic violence.
Okay.
It also includes another count, but just 1 count of domestic violence.
Let's make sure I get that right. Thank you. 1 second. Oh, I see. All right. So you're pleading guilty to 1 count of domestic violence in that other case. Do you understand?
I understand.
So because that case is set on another day ahead of today, if you fail to enter that plea, the prosecutor would have right to come back and withdraw this pretrial agreement because you wouldn't have complied with the other portion of it. Does that make sense?
Makes sense.
All right, thank you. Also, looks like the prosecutor is agreeing to dismiss, and this is another case, it's currently charged underneath case number 25-1048-FY. That involves an allegation of alleged stalking, and that is currently before the district court, and that case will be dismissed. I got that right, correct?
Yes, sir.
All right, thank you. So you're wrapping up 3 cases today with a plea, plus pleading next week in this other case in the district court. Is that correct?
Correct.
All right, good, thank you. Now, by entering those pleas, if this court accepts those pleas, you're not going to have a trial of any kind.
Count 3 and added count 5 remain central to this case. A felonious assault with a dangerous weapon and a 2nd-degree home invasion. The assault involved an axe, the victim being Jeffrey Allen Peterson. Court records reveal the violence and intent, a chilling reminder of the severity of these felonies. While some charges are dismissed, the guilty pleas underline the gravity of Mr. LaRoche's actions on that fateful day, June 26, 2025.
The right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you were to choose to testify. Mr. LaRoche, do you understand those rights?
Yes, I do.
And again, more importantly, do you understand that if you plead guilty and accept those pleas pursuant to this pretrial agreement, you will be forever waiving those rights as they apply to this particular case?
Yes, I do.
Additionally, any appeal as to the conviction sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim if the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to get you to plead guilty that we haven't yet discussed today?
Just the promise that if I plea out to these 3 charges, that the other ones will be dismissed.
Right, yes. So I'll cover that. Counts 1, 2, and 4, which include another count of felonious assault or assault with a dangerous weapon, and includes a home invasion 1st degree, and includes the assault with intent to do great bodily harm. Those will be dismissed.
Correct.
All right, thank you. Now, I trust that Mr. Ruck has gone over potential sentencing. I know he has because on the bottom of this pretrial agreement that you all have signed and Mr. Ruck gave to me, it says at the bottom, they have an estimation that the guidelines on the minimum sentencing guidelines here in Michigan would be roughly 19 to 38 months. The question I have for you is, has anyone promised you or told you exactly what the sentence would be?
No, just the 19 to 38 is all.
I want to highlight for you that on this piece of paper that you signed, it says the estimated sentencing guideline range is as follows, 19 to 38. It's an estimate, okay? The attorneys try to do their best job when they look at your prior criminal history or look at prior pre-sentence investigation reports from the Department of Corrections, and they're doing the best that they can, but it's just an estimate because I will determine in the end what the guideline range is. Okay, just need you make sure you understand that. Also, any recommendation as to a sentence is strictly that, a recommendation. Do you understand?
Yeah, I understand.
All right, good enough. Thank you. And the council can give you history about what how often does Judge Elmore, if ever, exceed the guidelines, things like that. But I just want to make sure no one's promised you anything. All right, knowing all that, do you still wish to enter the pleas of guilty that we discussed earlier?
Yes.
All right. As to count 3, felonious assault, or also known as assault with a dangerous weapon upon Jeffrey Allen Peterson involving the axe, how do you plead?
Guilty.
And as to added count 5, home invasion in the 2nd degree, how do you plead?
Plead guilty.
Okay. Before the court can accept that plea, I need you to tell me what you did that makes you guilty of those 2 offenses. Turning your attention to June 26th of 2025 out in Butterfield Township here in Missaukee County. Did you enter somebody's home or break and enter into somebody's home?
By pleading guilty, Mr. LaRoche knowingly waives critical legal protections: the right to a trial, the right to face witnesses, the presumption of innocence. These aren't just procedural formalities. They're fundamental rights surrendered in exchange for the plea deal. In the courtroom, every word matters. Every signature on the pretrial agreement seals a future shaped by these choices. This is accountability at its most formal.
Did you intend to assault him? Or did you maybe come up with that decision while you were there? Let me break it down a little bit better for you. The crime of home invasion 2nd degree requires that 1, you break and enter in a dwelling without consent. We've already covered that. And then either when you entered it or while inside or while exiting the dwelling, you elected to commit an assault or some other, or a larceny. I'm sorry, or a felony. Is that true?
Yes, I assaulted Jeffrey Allen Peterson.
All right, so while you were inside the residence?
Yes.
Okay, so while you're inside the residence, you then chose to assault Mr. Peterson, and and when you did that, did you do it with an axe? You can just tell me what happened.
Yes, I did.
Okay, tell me about what you did. Did you swing it at him? Did you hold it in your hand to demonstrate to him or show him, hey, I'm going to hit you with it? Or tell me a little bit more about what happened.
I guess I don't remember how it happened. I just hit him with an axe.
Okay, well, all right. When you hit him, how did you hit him? Did you hit him with the metal end or with the handle? What did you hit him with? It's up to you to tell me. I mean, I've got no skin in the game.
I must have hit him with the handle.
Yeah, you can't do that. You can't shortchange it. If you're going to plead guilty, you got to tell me what you did. Now, it may be difficult for you. That's up to you. I can't control how you feel about it or whether or not you want to. All I care about is what you tell me has to be true. And you have to tell me in your own words what it is that you did with that axe toward Mr. Peterson while you were inside the home.
I took an axe out of his hands and then I hit him with it.
How did you hit him with it? I mean, there's a lot of ways to hit him with it. For instance, I could take my pen and throw it at Linda, but I'm not going to do that. Or I could walk up to her with the pen in my hand and then hit her with the pen. I don't know. You got to tell me what you did.
if I may, Your Honor.
Sure, Mr. Roop, if you understand the facts better, go right ahead.
Mr. LaRoche, the testimony at preliminary examination was that, from Mr. Peterson, was that he was struck with the flat side of the head of the axe on his person. Do you recall that testimony?
Yeah.
Do you agree that that testimony is accurate?
Yes.
Thank you. Now, when you did this, was it out of self-defense? Tell me about that. Who started this scuffle between the two of you?
Can I start a little bit before this? Can I just tell you how it went?
Sure.
So I found a tracking device in my partner's car.
And your partner's car?
I also had discovered later on that he was the one that had placed that tracking device on the car. I reached out to him and he's the one that admitted it. He then wanted to sexually harass my partner and her daughter. So I made my partner drive me over there. You know, it's kind of hard to say I was defending myself on another
It's
man's
okay, just
property.
keep telling me what happened.
You know, I told her to bring me out there.
The court delves into why the crime occurred. A tracking device, suspicion, confrontation. Action spiraled into assault and home invasion. Mr. LaRoche claims a mixture of defense and retaliation, yet the law sees the facts clearly. Unauthorized entry, assault with a weapon, and a planned intent to commit harm. Even personal motivations cannot outweigh the legal consequences. The justice system moves forward.
Of course, at some point, two of you made your way into the house, is that correct?
Yes, because that's where the phone was.
And you didn't have his permission to go into the house with him, did you?
No.
And while you were in the house, even if it no longer involved the axe, you continued to assault him, is that correct?
Yes, sir.
Your primary motivation was to try to have him delete some sexually explicit photos and videos of your partner.
Yes, sir.
All right. Mr. Denham, I believe you provided a factual basis.
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your
And you believe the court's in compliance with the court rules?
Yes, sir.
Mr. Brooks, did you cover that when he went into the home and they were still fighting that he didn't have, or you did, that he didn't have permission?
That he did not have permission? Yes, I did.
Mr. Roop, do you agree with what Mr. Denham said?
I am satisfied, yes.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided under oath on the record satisfies the elements for the two offenses, counts 3 and added count 5. Therefore, the defendant is found guilty of those 2 counts. The remaining counts will be dismissed at the time of sentencing as long as the defendant complies with the other conditions of the pretrial agreement that include resolving the district court case involving a single count of domestic violence. All right, Mr. Roche, this case will be set for sentencing. We typically do sentencings in about 4, maybe 5 weeks. Between now and then, an agent from the Michigan Department of Corrections will prepare a pre-sentence investigation report. That report will include a description of the agreement, description of the events, the facts that occurred. It will also include potentially a statement from the victim. It will also include information that you provide while this report is being prepared. It will also include a score in the Michigan sentencing guidelines and include a recommendation as a sentence. Please keep in mind that the scoring and the recommendation are not binding, and they're merely that. There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet while you're in the jail. You'll complete that packet and turn it in. Also, you have the right to have your attorney present at the time they interview you, because an interview must be done. And number 3, Mr. Rupp, once he gets this report, which is typically about 2 weeks prior to sentencing, will have to come and go over the report with you, as each side has the right to come to this court and request corrections, such as scoring on the guidelines, and amendments or make objections to things such as scoring on the guidelines and things like that. All right. Anything further today, Mr. Down?
No, Your Honor.
Mr. Rupp, anything further?
Just one footnote for the record, Judge, because this was a universal agreement that is disposing of 3 cases.
Yeah.
Obviously, I'm the attorney of record here.
Yeah.
I'm the attorney of record on the domestic violence case. I have not been appointed to represent him on the alleged aggravated stalking case. But that I felt comfortable moving forward, stepping.
The plea concludes today, but the story is not over. A pre-sentence investigation will determine Mr. LaRoche's fate. Sentencing guidelines estimate 19 to 38 months, yet the final decision rests with the court. Multiple cases resolved, some dismissed, some awaiting future plea. This courtroom drama demonstrates the intricacies of justice, the procedural rigor, and the real-life consequences of criminal choices. Every detail will shape what comes next.